Now, go to appendix, what was it, 32? That's where I would direct your attention for right now. The 8.5 by 11, 1 page, everything you need to know about mechanics liens, everything you need to know except the 250 pages that were prior to that. But this is really what we're going through now are these actual deadlines. And I respectfully submit to you, they're not that important. Whenever you have a particular case, go look at appendix 32. Or maybe, read 4 or 5 pages out of the Virginia Mechanics Lien chapter to figure out exactly what your deadline is or whatever it is. I don't think, I guess part of what I'm explaining, I don't think it's a worthwhile use of time to get into this with a great deal of detail. But here's the rule. Here's your deadline in Virginia. I've been saying 90 days. That's because that's the lowest common denominator. You know you're okay in 90 days. You may have more time. It may be up to 120 days. Maybe, maybe not. But we could look at it when the time comes. This is what the statute actually says. Within 90 days from the last day of the month in which claimant last performs work, but not later than 90 days from completion of the entire project. What that means is, let's say your last work was in June. You go to the end of June, June 30th. You count 90 days, not 3 months, 90 days from the June 30th, July, August, September. So your deadline's probably September 29th, if I'm not mistaken, or it might be the 28th. The deadline is usually the 28th or the 29th of the month. So you could, if your last work was June 1st, you have all the way till September 29th. If your last work was June 30th, your deadline's the same, September 29th. So you may, because whatever day is your last day of work, you go to the last day of the month of that month and you count 90 days from then. However, semicolon, but not later than 90 days from completion of the entire project. What that means is if you happen to be the last guy that delivered anything to the project, you have a straight 90 days. You don't go to the last day of that month and then count 90 days. How do you know whether you were the last guy on the project? You don't know. If you think about it, that means a general contractor, anybody who's contract directly with the owner, you're always operating on a straight 90-day deadline, because by definition, you're always the last worker on the project. Whenever your last sub finishes or your crew finishes, the project's complete, and you got a straight 90 days from there. So it's really better, I'm explaining all this in some detail just so I'll tell you, because I'm going to do this probably on the other ones. The best thing I can tell you is you have a minimum of 90 days. It might be up to 120. It's somewhere, So when the time comes, read the chapter, focus on it, think about it. You might have up to 120 days, or give me a call. We may only have to discuss it 5 minutes. You have at least 90, you might have 120 days. It is a land record-based lien. You must do a title search if you want to get it right. I'm happy to do liens. It's what I call no warranty liens. I will do no warranty liens. They're cheaper. I can do them faster. But I'm also going to be telling you, I don't know if this is right or not, but it looks good. Let's just file it. If you're only owed $5 grand, you file a lien yourself if you're doing that. There's, well, actually, in my website are forms that come from the Code of Virginia, that come from they give them to you. All you've got to do is fill in the blanks and pay a $19 filing fee, and if you got it right, you're a secured creditor. Okay, then you got to enforce your lien within 6 months, not 180 days, 6 months of when your lien is filed. So no matter what day you filed the lien, You count 6 months, that's when you have to enforce it. That is by lawsuit. That is a more complicated procedure. And my firm is one of the few, truly expert mechanics lien litigation firms in the state or in this general area. It's a very specialized practice. It's a lot like doing tax law or something. If you don't do it all the time, you should not be doing it. And that's what we do for a living. Of all the liens, we file lots of liens, but it's maybe 10% of the liens we file get enforced, maybe 5%. It's a small percentage because you're not doing that unless it's a battle between innocents or there's some kind of big dispute. No, doesn't matter whether or not the money's due. These are hard, fast deadlines. The only thing that would affect it is a bankruptcy. You can be stayed. You have to go get relief. I do not need relief from the stay to file my mechanics lien. I do need relief from the stay to file my bill of complaint to enforce mechanics lien. But you have extra time. You're not facing a deadline either. So it's not all bad. All right, Virginia, there is a defense of payment. 150-day rule I'm not even going to get into, but really old. You can't go more than 5 months without getting paid, without doing something about it. But retention can be older than 5 months. Money held because of a pay when paid clause can be more than 5 months. So it's just rarely going to be a problem for you, but it is out there. We talked about the mechanics lien agent notice, the pre-notice. The waiver cannot be in the contract. Query, because of this new statute, it is possible that pay if paid clauses are unenforceable in Virginia now. That's what inquiring minds want to know. I would be thrilled to take your case all the way to the Supreme Court of Virginia on this, and we'll find out whether that pay if paid clause is enforceable. Okay, Maryland. Maryland's very different in several respects. One is, in Virginia and DC, you start by just filing this memorandum in the land records, and your lawsuit comes later. In Maryland, you got nothing until you get to court and the court rules on your mechanics lien. So the whole thing starts with the lawsuit. It's a lot more front-end loaded. You have a lot more expense and work earlier. You got to file it starts with your bill of complaint to enforce. Within 90 days after that, you have a show cause hearing. You have a preliminary hearing within 90 days. It's called a show cause hearing. But basically the whole case gets tried right there. And then they make you do it again in 6 months for the final trial. And if bankruptcy's filed so you're talking about 9 months after you file the lawsuit is when you're going to go to final trial. And then if the owner files bankruptcy within another 90 days after that, you've just been wasting the last year and the last 30, 40 grand in legal fees you've been wasting because your lien rights fail, which, it's a priority issue. You have to attach everything to the lawsuit you're going to put into evidence because you're going to serve this lawsuit on the owner, the banks, all these guys, and they need to see everything you're going to put in evidence. If you did not attach it to that lawsuit, you cannot introduce it into evidence at the show cause hearing. So again, it's a very front-end loaded process. You can't do it for less than $1,500, and it could be $2,000, $3,000, $4,000 just to file suit on a mechanics lien in Maryland. The good news, if there is good news, is you do have this show cause hearing coming up very quick. The parties can ignore your mechanics lien in Virginia. And, I have clients call me all the time that said, hey, somebody filed a mechanics lien on my house. It's usually a distraught a homeowner who's like, oh, my credit's ruined, a mechanics lien was filed on my house. And I'm like, just ignore them. Ignore it, it doesn't matter. they're not going to want to spend $1,500 to enforce that lien. They got to do that within 6 months. If they enforce the lien, we'll deal with it. Until they enforce it, ignore them. And that's a true story for defending mechanics liens in Virginia. There might be reasons you want to go find out, but there's no reason you have to. So but in Maryland, the bad news is you have all these front-end loaded early expenses, but the good news is they got to respond right away. And you're going to have them in court in 90 days on this show cause hearing. So you would think there's a better chance of things getting resolved early. And I think that used to be true. I have noticed for any students of the mechanics lien business out there, that really has been changing the last 5 years. And I'm not sure why, but it's become a lot more common for the owners and the banks to vigorously defend mechanics liens at the show cause hearing stage. They used to just agree to give you an interlocutory order. You didn't even have to go to the show cause. They'd agree to let you have the temporary lien, and then we'll go really try the case in 6 months. That used to be the norm. It ain't anymore. These show cause hearings are vigorously defended, and you can really lose on this preliminary hearing, but you can't really win. All you can win is the right to have a full trial in 6 months. So you end up trying the case twice is what ends up happening, even if you prevail both times. All right, now, if you do not have a contract directly with the owner, you must also mail a notice of intent to lien to the owner. This is different than the Virginia memorandum. The Virginia memorandum, which there's forms right out of the Code of Virginia, Appendix 24, 25, 26, 27. This Appendix 28 is also right out of it's out of the Code of Maryland. A notice of intent to lien form. You can Xerox this sucker, fill in the blanks, and mail it in. And you seriously can consider doing it on your own. It depends on how much you're owed. If you're owed 10 grand, maybe, a limit 5 grand for sure. If you're owed 100 grand, you want to let us do it. But see, the thing is, if you're owed 10 grand, you're not going to want to pay me 2 or 3 grand to enforce that lien. And that's why it makes sense. If you know you're never going to enforce that lien, go ahead and do the initial steps on your own if you want to. You're practicing law without a license, but I ain't going to turn you in. It's a pretty easy test to pass. You just gotta, you don't even have to exactly identify the owner. It's gotta be received by the owner or the owner's agent. So in the John Smith LLC case we were talking about in Virginia, and they sent their notice of intent to John Smith. Well, there's no doubt John Smith is an agent for John Smith LLC, so you did fine in Maryland. That's a fatally defective lien in Virginia, but it's okay in Maryland. You got to state with substantial accuracy the amount you're owed. I don't know what that means, but it probably means it doesn't have to be exactly correct. All right. There's no defense of payment in Maryland. You can make the owner pay twice with very limited exceptions that basically come down to people building houses on their own real estate that they already own. There is a defense of payment, but otherwise not. No known limit. You got the 15 and 25% rule that I'm not going to get into. It's discussed at great length in the book. But what it comes down to is that small projects, you don't have lien rights. It has to improve the value of the property by at least 15 or 25%, or nobody has lien rights. So that's not your contract, but the general contract. What's the size of this project relative to the value of the project is the question. And little projects, nobody has lien rights is what it comes down to. Same as Virginia, you can't have waiver in the contract, but in Maryland, It's explicit, there's no question. Pay if paid clause does not defeat mechanics lien or bond rights in Maryland. That we know for sure. All right, sale, these are all priority issues. Bankruptcy, the owner defeats lien rights, but the trust fund statute survives bankruptcy. So that's a place, the trust fund statute is real important in Maryland, is in the event of bankruptcy. All right, DC is a land record-based lien like Virginia. You got to do a title search, you file your memorandum in the land records, but you don't have to do that until 90 days of completion of the entire project. So you may still have lien rights, and I've done this. Maybe you haven't been on a project for a year and a half. You might still have lien rights if the project isn't done yet. What is an issue is you don't have lien rights in DC unless you have a contract directly with the owner or the GC. That's going to be a problem. All right, you have to file a lawsuit to enforce your lien rights within 120 days, 180 days of filing it in the land record. So it's similar to Virginia, but it's 180 days, not 6 months. Virginia is within 6 months after your lien filing. There is a defense of payment in DC. They require a lot of records. The other big problem with DC is the clerk. Depending on how much business you do in DC, you are very aware that dealing with bureaucrats in DC is just unbelievable. And the town council or the city council is very active with all kinds of laws. And this is basically to force you to be properly licensed in DC, which is a legitimate governmental concern, and I don't mean to say otherwise, but it's smart. But the problem is it gives you horrific problems filing a mechanics lien. And if you go into DC for anything, you must make sure you are licensed. You must make sure you have you're in good standing corporate-wise, and you're going to have to produce proof of that. The clerk will not accept your lien unless you're giving them an original certified certificate of good standing from their, Department of Assessments and Taxation that you're up to date on your taxes and you are licensed, So you have to leave time to do all that, I guess, is part of the point. And it makes liens in DC a lot more expensive. All right, Pennsylvania, very liberal deadlines. Your lien claim must be filed within 6 months of your last work. Appendix 29 is a lien claim. It's more like a lawsuit or an accounting that you file. You don't file it in the land records, you file it with the clerk. So it's more like a lawsuit. You file it with the clerk, and they have a book they keep lien claims in. You got to file that lien claim within 6 months of your last work. Subs, if you are a sub, not a GC, it's like the Maryland notice of intent to lien. You got to mail the owner a notice of intent to lien 30 days before you file the actual lien claim. Now, this is for no useful purpose that I am aware of. I think the idea is that the owner might just resolve the case real quick if you give them notice, but that simply isn't true. But it's a hurdle you got to make sure you get over. If you file your lien claim on 6 months, 2 days before your 6-month deadline, and you hadn't sent that 30-day, hadn't sent notice 30 days before, your whole lien fails. So really your deadline is 5 months after your last work is one way of looking at it, because you got to send the notice of intent and then you file the lien claim. And then you got 2 years after you file that lien claim to enforce. That's a pretty liberal deadline. So that's not a problem for you. What is more of a problem, well, defense of payment's kind of complicated in Pennsylvania. I might leave you mostly to look at the book, or it's in that summary. There is a defense of payment basically on any residential project. The other choice, you like this as a creditor, but they always have the option of getting a payment bond. And if they get a payment bond, then there's a defensive payment on the mechanics lien. You're fine with that. As we'll talk about in a few minutes, you'd rather have a payment bond than mechanics lien rights pretty much any day of the week. So you're okay with that. The hard part, and this is old, this is a new part about the payment bond. The general contract part's an old part. If they record the general contract, you're bound to it. In other words, you know the limit of the dollar value of that contract, and you are subject to a defense of payment. So that if you're going to supply a project in Pennsylvania, you might consider going and checking if the general contract's been filed, and you will be subject, you're a lot more worried about the owner paying the GC if that general contract has been filed. All right, no sub lien rights. It doesn't go quite that far. Okay, we really talked about this on the pre-notice. If the project is over $1.5 million, the project may be searchable. Those are usually commercial projects, regardless whether they're residential or commercial. The banks, if it's over $1.5 million, the bank's going to require that it be registered, so it's going to be, and you should just assume that it is. The good news is it's easy. You just go, this is on pages, page 12.3 to 7. Just go to that website and have a look, and you can see whether or not your project's listed. It's going to be, I'm going to tell you, it's just like a residential project in Virginia. There's always going to be a mechanics lien agent on the building permit. You got to get a copy of the building permit so you know. And same thing here. If it's over $1.5 million project, it's going to be searchable. It's going to be registered. But you need to go on the website and file your notice of furnishing. So the owner files a notice of commencement. It's optional by the owner, but it's always going to be there. It's going to be filed before work begins. If the owner files a notice of commencement, you must file a notice of furnishing within 45 days of your first work, not your last work, within 45 days of your first work. It must contain, if you go look at page 12-5, that's a list of what must be on there. I'm not going to get into it right now. The owner can do a notice of completion, but it doesn't really matter. It doesn't make any difference, but it's just kind of helpful information, I suppose. You can file a notice of non-payment. There's no deadline. It's not a requirement. It's also of no practical value, but you have the choice of filing a notice of non-payment, which you probably want to do, but it's of no legal effect. Okay, there's your summary.